Good afternoon, everyone.
Good afternoon.
My apologies, internet
Good
problem.
afternoon.
Why so sharp?
Good afternoon.
Good afternoon. Anyhow, you all can remember I said I was going to check to see how many cases were presented. You all can correct me if I am wrong, but I checked the ones I had written on. Oh, there was one more I had to check, so I could be off by 1 or 2. Cleopatra, I have you down for 3 cases. Is she on? Not yet. Alicia, I only have you down for 1. Sound right?
Yeah, the one would count as 3. Yeah, that's right.
I have you down for 2. Cleopatra on now. Thompson, I have you down for 2. Dora May 3. Janine 3. Mackenzie, I have you down for 5. Who next? Demetria, I have you down for 6. I'm not sure you did 6, but I have 6. And Janique, I have 3. So check your records and let me know if I need to add or subtract.
You sound like you give me one of Demetria one. She wouldn't mind.
She wouldn't mind? Yeah, saying nothing.
Demetria, you ain't saying nothing.
Sorry, I was trying to log in with a different device. You said 6. I don't remember 6, Ms. Archer.
I know.
Yeah,
I know.
That don't sound right.
So should I knock it 3?
There should be some subtraction. If it's not 3, it's 4 that I can remember.
Okay. See how honest she is.
Presenting 3.
Hold on. You might have to remember some of them I sent the email.
Right.
But yeah. And I didn't write it on it. Hold on, there's my eraser.
Yeah, I didn't present 6. No, ma'am.
Okay. So I'll put you down for
I
4.
can't be no more than honest.
Yeah. I know Mackenzie did the most. Because I have her down for 5. I remember hers. Because she's always on the ball. Yes, I'm ready to present. Okay.
That ain't true.
So that sounds right now, right? Cleopatra 3, Alicia 1. Who next?
Miss Archer, you keep forgetting the one with like 3.
Oh, your one was like 3. You remember the name of it? Because I'm gonna look it up. It was like 3. That was the Junkanoo one.
No, that was them people who the foreign people who was all confuddled up, and the lawyer only wanted to get the money, and they tricked the woman into buying the property, into selling the property to them, and she had dementia.
The one when the lawyer acted for both sides?
Correct.
Ah, and you're trying to say
He
that
o-
was more than one.
He
That
only
was-
wanted his $45,000.
Ah, okay. All right, so I'm gonna add some points onto the midterm. I'll put it on after I put in the grades for the final.
Oh,
Okay.
so Ms. Archer, the grades that Miguel would have emailed, that's just the midterm. You haven't added the cases yet.
No,
Oh, praise God. Okay, bye.
no. Remember, I told you all that. I said I have to go and check the cases. I would have written your names on it, and I would write down how many I have that you presented. I'll double check with you tonight, but I'm saying I won't add these grades on now because you all have also been participating in class. So when I put in the final grade, once you've done the final exam, I put that grade in. Then I will add on these for the cases, and then I'll add on some points for class participation.
So you add my one, Miss Archer.
Yes, I did.
Thank you.
Yes, I did. I've changed your number to 3. Okay, so that sounds fair. So the only way you could get below a pass is if you don't study. That sounds fair?
Yes, ma'am.
Okay, so if you study, you'll pass or get even higher. So on your final exam, you have to pass that final exam. And then from there, I will add on your points for your cases and your class participation. Sounds good?
Yes, ma'am.
Yes, ma'am.
Okay, no need to holler and scream. All right, so this is our class before the last.
Well, I did that earlier when I saw the email from Miguel, because I thought you had added the presentation points to that.
No. That I will
Okay.
hold. Yeah. See, because if I give those grades in now, right? They're hard and fast. You see what I mean?
Yes, ma'am.
Yeah, if I hand those in, then they're gonna add it on and that's it.
Okay.
Right. So I want to
Excuse
wait. Yeah.
Did I miss something? My apologies, I know I was missing. What is a pass? What grade is a pass?
Se-
Sorry?
70.
Okay. Thank you.
Mhm. Yeah. You could do this, man.
I think so.
You could do this. This ain't that hard. Especially how you had your little midterm. You don't be that hard. Okay. So let's talk about legal and credit risk for property mortgage transactions. So, you know, in the earlier chapter, we spoke about the banker-customer relationship. And we also spoke about the duties of the banker and the duties of the customer in general. And as you all are aware, that the banker-customer relationship is based on a contract. When you come to open an account, that account opening form is a contract. So the relationship between any lending institution and its client is based on contractual arrangement. It also has a bit of fiduciary duty in it, and also an acts of professionalism. So all of that is a part of the lending institution and that relationship with their clients, especially in reference to mortgages. So let's first look at the contractual relationship. Remember when we did the chapter, we said that the relationship between banker and customer is one of debtor and creditor. And that contract that you have when you open an account with a client was based on the express terms that were laid out in the case of Johansson versus Swiss. But also within that relationship with your client, there are implied terms. And implied terms means that these are terms that are part of the normal banking relationship and interaction between the bank and the client. Now, whenever a client moves from simply opening an account to being offered other services, there are other contracts that a client will enter into with the financial institution, such as the mortgage. So within each of the contracts, there are duties, there are obligations. And a customer has to know what their duties are, the same way the bank has to know what their duties are and what are their obligations. The client has to know what their obligations are. So these duties and obligations, again, when they sign that account opening documentation, they have to read it. It's the same way when they're signing all of the documents to obtain a mortgage. They have to read the documents. They have to know what their obligations are, what their duties are, and also what is customary here in the Bahamas. And as with any contract, there are liabilities. So they have to be aware of what happens if there is a breach. Because even right up to today, even with the Homeowners Protection Act, you see a lot of clients are still very angry when the bank decides that they're going to exercise their power of sale. Again, they're not realizing that it just arises by law. That has nothing to do with the bank, whether they like you or don't like you. It's expressly stated in the mortgage deed. And it is a contract. So like any other contract, there are always certain rights, there are indemnities, there are protection, legal safeguards in that banker-customer relationship. But being a banker also means that you have a duty of due skill, care, and attention. So being a banker is different from being an ordinary person. You're expected to carry out your duties at a particular standard. And that standard is the standard of what a reasonable man would expect from a banker. Now, if you are a professional, such as a lawyer or a CPA or a doctor, they expect you to be at even higher standard of care. And of course, in that banker-customer relationship, you have a duty to act as a fiduciary. And you're gonna hear this term fiduciary over and over again in banking. You'll hear it even more in trust business. And that word fiduciary, you've also hear it when if you were to do company law. Because directors have a fiduciary duty to the company. So that word fiduciary and what it means was established in the case of Bristol and West Building Society versus Mathau. So if you want to, you can look it up, but I'm going to read to you just a little bit of what it is. You could either look it up or I could send it to you later if you're interested. Any interest? Or wait until I tell you what it's about.
That one, the last part.
So the solicitor acting in the land purchase transaction for his lay client and the plaintiff had unwittingly misled the claimant by telling the claimant that the purchasers were providing the balance of the purchase price themselves without recourse to further borrowing when he knew that they were using an overdraft to obtain further funding. The plaintiff claimed in breach of trust. And the court held that a claim for damages for a solicitor's failure to disclose the existence of a second mortgage must show that the damage flowed from the failure alleged. And in that case, Lord Justice Millett said, a fiduciary is someone who has undertaken to act for and on behalf of another in a particular matter, in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. This core liability has several facets. A fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interests may conflict. He may not act for his own benefit or the benefit of a third person without the informed consent of the principal. This is not intended to be an exhaustive list, but it is sufficient to indicate the nature of fiduciary obligations. They are the defining characteristics of the fiduciary. He is not subject to fiduciary obligations because he is a fiduciary. It is because he is subject to them that he is a fiduciary. A fiduciary who acts for two principals with potentially conflicting interests without the informed consent of both is in breach of the obligation of undivided loyalty. He puts himself in a position where his duty to one principal may conflict with his duty to another. This is sometimes described as the double employment rule. And finally, the fiduciary must take care not to find himself in a position where there is an actual conflict of duty, so he cannot fulfill his obligations to the one principal without failing in his obligations to the other. If he does so, he may have no alternative but to cease to act for at least one and preferably both. The fact that he cannot fulfill his obligations to one principal without being in breach of his obligations to the other will not absolve him from liability. As to breach of duty, breach of fiduciary obligation, therefore, connotes disloyalty or infidelity. Mere incompetence is not enough. A servant who loyally does his incompetent best for his master is not unfaithful and is not guilty of a breach of fiduciary duty. If the trustee has benefited from the breach, the court would order him to account for it on the application of the beneficiary. And this was referred to as being restorative rather than compensatory. So that case of Marthal established what is the fiduciary duty and what it means. And so the key thing here is to remember the characteristics of a fiduciary. He said the fiduciary, he is not subject to fiduciary obligation because he is a fiduciary. It is because he is subject to them that he is a fiduciary. You understand what he's saying? So that's key in understanding when these fiduciary obligations arise. So in essence, a fiduciary must act in good faith, not make a profit out of his trust, not place himself in a position where his duty and interest may conflict, and not act for his own benefit or the benefit of a third person without the informed consent of his principal. So remember the case that we did with the female attorney, where she acted for, yes.
Yeah, that one I present, I remember that one.
Okay, and she had a fiduciary duty to both principals. And when she found that she was in conflict, she should have recused herself from both.
Right. And she benefited by way of receiving payment
Exactly.
without, I
Didn't take a,
guess. Okay, I get it.
yeah, she didn't take a retainer, but she then turned around and charged them.
Mhm.
But be mindful that not every breach by a fiduciary is a breach of fiduciary duty. Because the person is fiduciary, that duty is something that he's subject to. But if he breach it, that doesn't mean that he's breached his fiduciary duty. It has to actually be a fiduciary duty as the ones that are set out in this case of Martha versus Bristol. It should be noted, however, that the House of Lords, in the case of National Westminster Bank versus Morgan, it stated that the banker-customer relationship is not merely a fiduciary one. And in that case, it did not give rise to a presumption of undue influence. A fiduciary relationship is only presumed and legally develops if the bank expressly acts in a manner that may attract the presumption that it has, by its actions, assumed a fiduciary role in relation to its customer. And that's why you sometimes see a lot of managers and even your legal department would always say, be careful of what advice you give a client. Because you could walk into the realm of acting as a fiduciary. And by doing so, then you can actually cause the bank to be liable for breach of fiduciary duty based upon the statements that you made. Let me see if I have that one. No, I don't have that one. Let me see. I had another case here. You know, I'm always trying to find cases for you, all right? Okay. And this case of Arklow Investments versus ID McLean and others, it referred to the case of Bristol and West Building Society on who is a fiduciary. In this case, this is appeal from the judgment of the Court of Appeal of New Zealand. It raises the issues relating to the concept of fiduciary duty. And it results from the sale of Matakana Island, which lies across the entrance to Tauranga Harbor on the eastern coast of the North Island of New Zealand. A forest consisting mainly of radiata pine extends over much of the area of the land, which approximates 4,300 hectares. The vendor of the sale in question was Matakana Forest Limited, which had been placed in receivership in October 1990. The receivers put the island up for sale in February 1991, and it remained on the market until the sale was negotiated in late 1992. During that year, milling of the mature trees was in operation. Now, when you hear that word receiver, what case comes to your mind? Because everybody got that question right.
Okay.
Of course. And you all could remember what are the duties of the receiver? Going quiet. Okay, so the relevant facts. Summarized. The background to the proceedings can be stated quite briefly. The appellant, Mr. Wingate, had become interested in the purchase of Matakana Island in July 1991. His intention being to develop the land for residential, recreational, and resort uses. Arklow Investments Limited was to be the vehicle for this venture. On the 15th of June, 1992, the FAR group of companies, which operated a merchant banking business, were approached on behalf of Mr. Wingate with a view to obtaining the group's assistance in raising finance to enable the proposal to proceed. Mr. Wingate had previously employed another merchant banker, Fay Rich White and Co., for that purpose, but their relationship had been terminated. On the 16th of June, 1992, in response to that approach, FAR made a written proposal setting out the terms on which it would accept appointment. Those terms were not acceptable to Mr. Wingate. On the 15th of July, 1992, FAR gave written notice of withdrawal of its mandate offer. FAR proceeded to broker arrangements with other parties for the purchase of the island, which ultimately led to the February 1993 sale now in question. The transaction initially comprised a composite arrangement under which ITT Rainier Limited had acquired the forestry right to the mature standing timber. Ernst Law One Limited acquired the land. The remaining timber had some associated assets, and the FAR group member company acquired the balance of the assets, particularly the mill and the mill land. The total purchase price was $20.7 million, of which $50,000 was paid by the FAR interests. This transaction, originally negotiated in November 1992, was restructured to overcome statutory requirements governing acquisitions by overseas interests. There has always been a subsequent rearrangement of interests which are not relevant to matters now in issue. In broad terms, the appellants, for convenience, referred to as ACLAW, contend that in taking the actions it did leading to the November 1992 transaction, FAR breached its fiduciary duties to ACLAW. So two separate causes of actions were pleaded in that respect. So in an interim judgment delivered in the High Court, Judge Tam answered a series of specific questions governing the issue of liability. They were framed as follows. In relation to the cause of action of breach of fiduciary duty owed by FAR to ACLO/Wingate, A, whether the FAR interests owed a fiduciary duty to the plaintiffs, and B, if there was a fiduciary duty, did FAR breach any fiduciary duties? In relation to the cause of action of misuse of confidential information, as to whether FAR financial and or other of the FAR interests received confidential information, one was whether those defendants received the information which the plaintiffs claimed to have conveyed. Two, whether such information as they did receive was confidential, and B, whether the FAR interests were under an obligation not to use the information received by them other than for the purposes for which it was conveyed. C, if the FAR interests received confidential information and were under an obligation not to use it other than for the purposes for which it was conveyed, whether they did use it other than for the purposes for which it was conveyed. And D, if detriment to the plaintiff is a relevant ingredient of a cause of action founded in breach of confidence, whether or not ACLAW Wingate suffered any loss or damage, and hence any detriment as a result of the FAR actions. So you see, it's not only in the Bahamas where these things happen. So the argument was really whether there was an overlap between the duty not to be disloyal and the duty to respect confidence. A major plank in ACLAW's case was that FAR did have a fiduciary duty which was wider than the duty not to misuse confidential information, and extended in the circumstances to that described by Galt J as one not to promote or become involved in a competitive acquisition of Matakana Island, whether or not confidential information had been used. It is immediately apparent that protection of confidential information may be involved in or form an integral part of such a duty, and misuse may be evidence of a breach of that duty. But as the case was pleaded and argued on the basis that there was a fiduciary duty, that there was a duty which was actionable for breach, in the absence of any misuse of confidential information, it is necessary to consider that contention. The first issue, therefore, is whether FAR owed a fiduciary duty of that nature to ACLAW. So the court then went to discuss the duty of loyalty. And in the duty of loyalty, that's when they brought in the case of Bristol versus Marthal. Then the second matter they discussed was the misuse of confidential information. The question was whether FAR breached its obligation of confidentiality. And here they said it is common ground that the obligation not to use confidential information attaches only to information which has the necessary element of confidentiality and continues only so long as the information remains confidential. So the court identified 6 items of information which he held were confidential and had wrongly been used by FAR. They were A, that the assets available for sale by the receivers could be bought for $20 million. B, that the mature forest, aged 17 years and over, could be sold for $13 million and maybe more if an estimate of value of $15.75 million could be sustained. Third, that the immature forest could be sold for $3 to $4 million for the radiata trees, and the eucalyptus trees could fetch up to $3 million in addition, depending on market forces. 4, that the mill had a breakup value of $1 to $1.5 million. 5, that ACLAW had a buyer for the mature forest, which was willing to provide $15.75 million in cash. 6, that ACLAW's scheme was practicable and feasible if suitable financial arrangements could be made. The sources of the information were the discussion Mr. Bailey had with the FAR directors on the 15th of June, the Fay Rich White document, and the ACLAW brochure distributed as from the end of June. The scheme referred to was described by Justice Tem as one by which ACLAW could acquire the whole of the assets without putting up cash of its own, providing approximately $5 million could be raised on the security of assets other than the mature forest. Some observation as to the confidential nature of this information can be made. And so then the judge went through all of the various figures that they disclosed that they should not have disclosed. So he says near to the conclusion, in essence, the evidence showed that the transaction which FAR had put together, resulting in the purchase, did not utilize the ACLAW forest valuation, did not involve Kanimatsu, did not involve any resort development of the island, and did not result in FAR obtaining ownership of the land without expenditure of its own. Even though FAR was galvanized into other action by reason of his knowledge that ACLAW was in a relatively advanced stage of implementing its scheme, it is not possible to translate that into actionable misuse, particularly when regard is had to the considerable time lapse down to November 1992, when the FAR transaction was finally negotiated. As the majority of the Court of Appeal held, supported by Judge Blanchard, there is no basis upon which ACLAW could be entitled to relief. Its prospects of successfully concluding an arrangement with the receivers was not shown to have been adversely affected by FAR's use of that knowledge. Any possible advantage it may have obtained are dissipated by November 1992. Without further elaboration or unnecessary repetition, their lordships will respectively adopt the reasoning of the majority, concluding that no actionable misuse of confidential information was established. On this head too, the claim must therefore fail. So you can see normally when you bring an action for breach of fiduciary duty, along with that comes breach of confidentiality. So conflict of interest obligation and the contractual and fiduciary duty not to disclose or use confidential information belonging to a client may occur in the context of the duty of confidentiality, which has to be observed, upheld, and protected by all financial institutions. So that general duty of confidentiality, that runs in all banks, all financial institutions, not just here in the Bahamas. But our duty of confidentiality extends further than other jurisdictions. So the common law duty and statutory duty of confidentiality of banks and trust companies, credit unions, lending institutions, have become the hallmark of the financial services industry in the Bahamas. The duty of confidentiality is generally an implied term in a banker-customer relationship. Although it may be expressed as a part of the terms and condition on the client account opening documentation. So in the Bahamas, under the Banks and Trust Companies Regulations Act, Section 77, it speaks to preservation of confidentiality. So if I go back, the common law case of a banker having a duty of confidentiality was established in the case of Turnier versus National Provincial and Union Bank of England. And that case also gave the exceptions to the duty of confidentiality. So that duty of confidentiality that a banker has to its client is generally a fiduciary one. And the banker can be sued for breach of contract for anything that he states that is unlawful or anything that he discloses that is unlawful unless it fits into the exceptions. So that duty of confidentiality extends beyond what a banker discloses or what a banker says. It also extends to the customer's identity, its assets, its liabilities, and its financial affairs generally. A bank can be sued and an employee can be terminated for breach of the duty of confidentiality. So in the act, it says, no person who has acquired information in his capacity as a director, officer, employee, or agent of any licensee or former licensee. B, consul and attorney, consultant or auditor of the bank, or as an employee or agent of such consul and attorney, consultant or auditor. C, consul and attorney, consultant, auditor, accountant, receiver, or liquidator of any licensee or former licensee, or as an employee or agent of such consul and attorney, consultant, auditor, accountant, receiver, or liquidator. D, auditor of any customer of any licensee or former licensee, or as an employee or agent of such auditor. E, the inspector under the provisions of this act. F, a supervisory authority, or as a director, officer, employee, or agent of a supervisory authority, shall, without the express or implied consent of the customer concerned, disclose to any person any such information relating to the identity, assets, liabilities, transaction, or accounts of a customer, of a licensee, or relating to any application by any person under the provisions of this act, as the case may be, except for the purpose of the performance of his duties or the exercise of his functions under the act, or for the purpose of the performance of his duties within the scope of his employment. When a licensee is lawfully required to make disclosure by any court of competent jurisdiction within the Bahamas or under the provisions of any law of the Bahamas, for the purpose of enabling or assisting the bank to exercise any functions conferred upon the bank by any written law. In the case of a bridge institution, to the minister or his designate. In the case of an asset management vehicle, to the minister or his designate. To a person with a view to the institution of, or for the purpose of criminal proceedings, disciplinary proceedings, within or outside of the Bahamas, or disciplinary proceedings relating to the discharge by a public officer or member or employee of the bank of his duties. So under common law and under statute in the Bahamas, there are 4 exceptions under which you can disclose information, a client's information. One is under compulsion of law. So that's when you would normally file a suspicious transaction, or you receive a request from the Attorney General's office, or you receive an order from the FIU, or you receive an order from the police department. Other exception is when it's in the public's interest, which means that we may find that there is a client who is breaking the law or who is acting as if they have a license. And in the public's interest, you can disclose that information to the relevant authorities. In the bank's interest, if the bank feels that there is a client that could be detrimental based on its actions to the bank itself, it can disclose that information to the regulator. And the 4th exception is with the express or implied consent of the customer. Any comments so far? So as bankers, Section 77 of the Banks and Trust Companies Regulations Act, you need to read it. Any questions?
No, ma'am.
No? Oh, isn't that wonderful? So let's just say your bank has a head office. Can they disclose information on the client here in the Bahamas?
No,
No? You sure?
under what circumstances?
Only unless it's under the 4 exception.
Sure, sure, sure? Sure, 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 sure. How many of you have read this section? Anybody? No? Nobody has read the new Banks and Trust Companies Regulations Act?
No.
What?
The
Bankers?
CRF?
Huh?
You mean the CRF?
No, the Banks and Trust Companies Regulations Act 2020.
No, I haven't.
No, you need
I
to
haven't
read.
read it.
You need to read that the last act was repealed and replaced. You have to read this. Remember, I don't know if you would recall in the last Banks and Trust Companies Regulation Act, the duty of confidentiality was section 19. Is now section 77.
Wow.
Yes, you need to read it. So it says in section 77, subsection 6, to facilitate regulatory cooperation within the Bahamas, the governor or any director, officer, employee, agent, or advisor of the bank may cooperate with any other domestic regulatory authority, including by sharing information on the beneficial owners, directors, officers, and operations of a licensee and any of its affiliates, or any other information acquired in the discharge of functions and duties under this or any other act, where the governor considers that such cooperation or information may be relevant to the functions of such other regulatory authority, or as a necessary part of a framework for consolidated supervision, oversight, or regulation of the financial services sector. This is why you see all the regulators work together now.
That was done, I think, if I'm questioned, was that done in relation or come into play with the Credit Risk Bureau or something like that we're trying to implement or we have implemented?
No, that part was always on the books.
Really?
Does it have anything to do when they were saying that they have to disclose who have these monies in these foreign bank accounts in government? Or possibly?
Let me see. Let me see if that mentions anywhere. Now, under section 8, the central bank has the authority to enter into memorandum of understanding with other supervisory authorities around the world. So like the Canadian banks, there's a memorandum of understanding with the supervisory authority in Canada. So for consolidated supervision purposes, information goes from your bank to the head office. You know that, right?
I am aware of that, yes.
Right.
Why
That's
ask this
subsection
actual-
8.
Subsection 8, the portion you had read, I think it was, you said 77,
Yeah,
where you
section
said the governor and the central bank of the passing the information in order to do some type of regulation. That was there prior to them implementing the credit bureau?
Yes. Section 6, the one, but facilitating regulatory cooperation. That
Yes,
was, that was there before. This is like if you wanted to apply for a license,
Mhm.
what they will do is they will share that information between regulators to see if you've applied for a license somewhere else and to find out if you're fit and proper.
Okay.
Yeah.
So why I asked that is because I know with the credit bureau, I remember one of the meetings they had, they were discussing that we can't just give our clients information and all of that in order to be uploaded into like a central hub so that anybody could go in and view it.
No, that would be that would be a breach.
Huh.
Yeah.
Okay.
The public can't view.
No, the public isn't going to view it. However, if you are working to one of the financial institutions, all of their, I would say, creditors really are supposed to go into this credit bureau kind of, this is one overall thing that everybody's supposed to use and be able to access, but different financial institutions supposed to be able to access this. That way you would know exactly how this particular creditor, what their, I guess, history looks like.
Okay. And what did they say?
They mentioned that same thing you've just finished reading, where permission isn't needed from the client prior to providing them with this information in order to upload.
Yes, as long as they would fall into that category. Under the BTCRA, which is they would fall under, what's the terminology they use? A domestic regulatory authority.
Okay,
Fall under that category. If they're deemed to fall under that, then that's it.
okay, so I guess they don't need approval.
And it says here, wherever the governor considers that such cooperation or information may be relevant to the functions of such other regulatory authority.
Yes, ma'am.
Yeah, so it gives them a wider scope. I'm looking now under the Credit Reporting Act.
In
Right?
terms of the credit bureau, I know with our company, we had to pass a resolution. We had to pass a resolution to give out our members information to the credit bureau. So what we had to do was actually do all our applications, our loan applications over and implement this new permission that we would get from our members, indicating that we are now sending, if need be, their names to the credit bureau to get information on them. So that was something that we had to implement. We can't just get information from the credit bureau on them.
Mm. So your general terms and condition didn't include an overall express.
I guess not. This was something that we just had to implement based on requirements that was requested.
So that probably meant that the wording wasn't there to include all of the permission to just go ahead. Let me see what this is saying here. A data subject is entitled to know what information in respect of the data subject was submitted to a credit bureau by a credit information provider. Access data subject information relating to the data subject kept, maintained, or otherwise processed by a credit bureau, and obtain annually from a credit bureau a copy of the data subject's credit report without cost to the data subject. But I don't think we're at that stage just yet. Because it says here under section 25, consent requirements. Except with the consent of a data subject, a subscriber shall not request or obtain a credit report for a permissible purpose in respect of the data subject. A credit bureau should not release data subject information to a user that is not a party to a subscriber agreement unless the credit bureau verifies the identities of the data subject and the user, verifies that the data subject has given consent for the release of data subject information to the user, and uses reasonable means of transmission that ensures that the data subject's credit report is not altered, modified, or corrupted during the transmission process. And consent could be electronic, prominently displaying information regarding the consent in a clear and comprehensive manner in an application for credit, insurance, employment, or tenancy, and any other method. And of course, it says here that the central bank has the authority to request information from the credit bureau. And of course, the credit bureau has, with the permission of the central bank, they could subcontract any part of their processing of the data. But this isn't 100% functional as yet, correct? Because the last time I checked, they were still trying to get information.
Well, I know we using it, so I don't know how functional.
So how are you using it?
Well, I know there was one of our members, there was a loan that was not approved on their behalf, and they went to another financial institution, and that financial institution, they wrote into the credit bureau to get their credit score, I guess, on this particular member. And because he was delinquent with our company, his loan that he was seeking with another company was denied. So they are using it. They are using it in terms of finding out how you are paying or dealing with your creditors.
Mhm. Okay, because I'm looking at the regulations. And the regulation states that a credit provider that denies credit in whole or in part to a data subject as a result of information contained in the credit report regarding the data subject shall provide to the data subject within 15 days after making the decision an adverse action notice, informing the data subject of the name, address, and phone number of the credit bureau that provided the data subject information. The data subject's right to dispute such information with the credit bureau, and where the information is erroneous or outdated, to have the erroneous or outdated information corrected. A credit provider shall be deemed to have notified a data subject under this regulation, where the credit provider sends an adverse action notice by registered mail to the data subject's last known address. So it says here that the data subject could have actually requested a credit report. Before they even went through that long process. It says here, a credit bureau shall protect the confidentiality of data subject information received, collected, or otherwise processed under the Act and these regulations. And a credit bureau shall only report or release data subject information to the data subject concerned, subject to paragraph 2, to a user as otherwise required under the Act. And they have to utilize the information referred to solely for the purposes settled in the Act. And a credit bureau shall observe through its shareholders, directors, officers, and employees or agents a duty of confidentiality with regard to the information obtained by the credit bureau under the Act or the regulation. We see that duty of confidentiality runs through the credit reporting regulations also. So under the common law principles espoused in Barclays versus Taylor and Robinson versus CIBC, they demonstrate clearly and unequivocally the fact that courts will not encourage nor allow fishing expeditions by third parties into the financial affairs of banking customers. There has to be a clear and cogent evidence presented to the court for an application for an order to be issued regarding the disclosure of a customer's banking or financial information to a third party. With regard to the disclosure of a client's banking, financial, or other ancillary information by Bahamian subsidiaries, the case of the Bank of America Trust case, equity number 923, is a notable Bahamian case on the duty of confidentiality And in that case, the Bahamian court will not condone attempts by a foreign court to pressure a bank licensed in the Bahamas, but having its parent company in that foreign jurisdiction to violate the banking confidentiality laws of the Bahamas. In presenting the decision, in the case of Bank of America Trust case, the judge used the dicta from R versus Grossman, which stated clearly that branches of the same bank in several jurisdictions with different entities separate from each other and therefore subject to and governed by the local laws of the country in which they domiciled. So early in our banking history, we had a lot of branches. So if there were branches, then of course the head office could dictate what they wanted from those branches. But over time, they would change all, they were converted to subsidiaries, which means that they have their own board. And mine and management is supposed to be here in the local jurisdiction. So it's highly recommended that you have a carefully drafted waiver indemnity clause included in your terms and condition form. And that should be signed by the clients. In order to obtain the express consent of the clients to allow this confidential information to be vetted by a third party, even though it could be the parent company of the bank. It is only by this means that such information will be able to be disclosed legally to a third party under one of the 4 qualifications of the duty of confidentiality. So under section 77, subsection 2 of the Banks and Trust Companies Regulations Act, it does allow information approved by the inspector to be transferred to the head office of a branch or subsidiary, like I said before. But it has to be solely for collation and synthesis or processing of information. The Banks and Trust Companies Regulations Act, subsection 5, allows the governor to provide information on the beneficial owners, directors, officers, and operations of a licensee to another supervisory authority. Under subsection 6, the governor also has the power to provide the foregoing information to domestic regulatory authorities. And any breach of the duty of confidentiality is subject to a fine of $25,000 or 2 years imprisonment or both. So whenever you speak about the duty of confidentiality in the Bahamas and in other financial jurisdiction, there is a wider scope to this duty of confidentiality. Because internationally, you also have the Data Protection Act, and we have the Data Protection Act of the Bahamas. And all financial institutions have to be in compliance with both. So when you speak about data protection, it's talking about the privacy of a person's personal information. So even though you have the Credit Reporting Act, the Credit Reporting Regulations, you know, the Banks and Trust Companies Regulations Act, you also have the Data Protection Privacy of Personal Information Act. And this focus really on consumers locally and jurisdictionally. And is based upon the privacy principles established by the OECD. And is talking about privacy and the flow of a person's information. Now, we were supposed to have been, prior to COVID, looking at amending this legislation because Europe has already amended their legislation and it is quite extensive. So whenever you do business with Europeans, you have to comply with their data protection laws. So one of the primary objectives of the Data Protection Act is to ensure that information is obtained by fair and lawful means, and that it is used in a manner consistent with that for which it was collected. And you see the same thing when you read the Preservation of Confidentiality under the Banks and Trust Companies Regulation Act. It speaks to using the information. When you obtain the information, you have to use it for the purpose for which it was intended. So under the provision of the Data Protection Act, the persons collecting and using personal data on individuals are required to observe and abide by specific standards of confidentiality in respect of data, and they are prohibited from transferring personal data to jurisdictions with less stringent data protection legislation. And you cannot do that without the consent of the person from whom the data is obtained. So under the Act, it gives you the definition of data, which means information in the form in which it can be processed. Personal data, which means information relating to an individual, living individual, who can be identified either from the data or from the data in conjunction with other information in the possession or control of the data controller. The data controller themselves, which means a person who either alone or with others determines the purposes for which the manner in which the personal data will be processed. And then of course, the data processor. And that's the person who processes the personal information on behalf of a data controller. And of course, the subject is the individual. So the Act applies to both public and private sectors and to the Crown. However, the Act does not apply to personal data which is obtained or used for matters relating to national security. Information that is required by law to be made available to the public by the data controller, and information obtained, secured, and used for family, household, and recreational purposes. The Data Protection Act applies only to data controllers who are connected to the Bahamas. And that means that they have to be ordinarily resident, a company incorporated or registered in the Bahamas, or an individual who maintains an office or a branch or agency or practice in the Bahamas and processes the data in connection with the business establishment. Or a data controller is not established in the Bahamas, but uses equipment in the jurisdiction for processing data that is not restricted to data in transit. So to protect the privacy of individuals and achieve the primary objective of the legislation, the data controller must be satisfied of the following principles in relation to the collection, quality, and use of personal data. The data should be collected and used fairly and by lawful means. It should be accurate and kept up to date. And remember the same thing you just heard from the Credit Reporting Act, where the information has to be kept up to date. The data should be kept for specified purposes. Again, the BTCRA and the Credit Reporting Act speaks to that. The data should be adequate, relevant, and not excessive in relation to the purposes for which it is kept. Same thing in both pieces of legislation. The data should not be disclosed in a manner that is inconsistent to the purpose for which it is kept. Again, same thing. The data should not be kept for longer than is necessary, except where the data is historical, research, or statistical data. And lastly, the data should be kept securely from unauthorized access, alteration, disclosure, destruction, or accidental loss. Now, an individual, just like under the Credit Reporting Act, they have a right of access to personal data that is kept on them, except where the personal data is kept for the purpose of preventing, detecting, or investigating offenses, prosecution, tax collection or assessment, or if the personal data is prejudicial to the security or maintenance of good order in a prison or detention center. The right of access does not apply to legislation for the protection of individuals against financial loss arising from dishonesty or malpractice, legal professional privilege, matters relating to the protection of the international relations to the country, statistical research, or backup data. An individual has the right of rectification or erasure for personal data that is inaccurate. And of course, the individual is afforded the right to prohibit the processing of personal data for the purposes of direct marketing. The data controller has a statutory duty of care to the data subject imposed on him by Section 12 of the Act. And the data subject may bring a lawsuit against the data controller for breach of the statutory duty of care where applicable. So disclosure can happen in certain interests, and that protection that the data protection gives is overridden in circumstances where the data is in the interest of national security, or the data is being used for criminal investigations or prosecutions, collection of taxes, duties, and other levies, the protection of international relations, to prevent injury, damage, or loss to person or property, any disclosure required by an enactment of law or the enforcement of a court order, any disclosure made to the data subject concerned or to a person acting on his behalf, and any disclosure made to request or consent of the data subject or person acting on his behalf, and any disclosure required for the purpose of obtaining legal advice. So as you all are aware, we do have a data protection commissioner, and that commissioner has the power to issue information, enforcement, and prohibition notices. He can appoint officers. He can have inspection and examinations. He could restrict the transfer of personal data across jurisdiction, and he can also prosecute. So what are some of the important aspects of legal liability? Because as you can see, dealing with mortgages and just dealing in generally with the banker-customer relationship, there is legal liability because it is a contractual relationship. It is also a professional one, and you also have, in certain instances, a fiduciary duty. So there are other aspects of potential actual legal liability that has to be observed in contractual relationship between financial institution and their clients. You have contributory negligence. You have exclusion clauses. You have consumer protection, misrepresentation and mistake. You have undue influence. You have tortious liability. You have negligent misstatement. You have breach of trust, and you have restitution. All of these are legal liabilities that can arise from the contractual relationship between a banker and its client. So whenever you look at an agreement that's being drafted between a banker and its client, there are certain terms and conditions that should be there. You have the parties, the scope and the nature. You have the duties and the obligations, the rights, the responsibilities, the prohibitions and the restrictions, the standards and the service levels, the minimum acceptable service provider characteristics, monitoring and reporting if it's applicable, transition requirements, contract duration, termination and assignment, if assignments are permitted, the governing law, arbitration and litigation, exigencies and contingency provisions, contractual protection against liability. You look at sometimes arrangement to call for obtaining a license. It could involve intellectual property, proprietary information, could be ownership, duration, dispute resolution, risk assessment, management and mitigation. And we talk about risk assessment when we did the environmental impact assessment, indemnification, limitation of liability, contract inducements, termination, assignment, foreign-based service providers, regulatory and legal compliance, and of course, the risks that are inherent in that contractual relationship. And those risks can be compliance, legal, liability, operational, regulatory, and reputation risk. So there are effective action steps in managing legal and other risks in a contractual relationship. The action steps that a financial institution should follow in ensuring the legal validity effectiveness and risk management of his contractual relationships, and agreements which underscore such relationships are the following. Specifically discuss and document client and service provider expectations, performance standards and scope and ambit of duties, obligations, responsibilities, and rights. So my first question to you is, when someone comes in and they are applying for a loan in order to obtain a mortgage, do you discuss the expectation, the scope, and the ambit of their duties and obligations, their responsibilities, or do you leave that to the attorneys?
We would discuss all of that.
Yeah, normally you would discuss all of that, I guess. You let
Okay.
them know exactly what is to be expected and yeah.
So look at all of the cases that we read. Doesn't it give the appearance that the clients don't seem to be aware of what is expected of them? Or is it that they just play like they don't know in order to gain sympathy from the court?
No, they seem as though they don't understand, as though it wasn't explained properly.
Yeah, the last part.
And we saw that in practically every case, right? Yep. So review all existing client and other agreements for legal, regulatory, and financial compliance. Conduct internal audit of all legal and contractual documentation. Review and address client complaints, particularly those based on contractual duties and performance standards. Assess and understand the specific contractual provisions and their relevance, effect, and impact internally and externally. Conduct ongoing staff training on contractual documentation and implementation. Educate clients and all relevant stakeholders on the important provisions on the contract or the agreement and the nature and scope of the contractual relationship. Protect and preserve client information and financial institutions' confidential information, trade secrets, policies, and procedures. Ask the appropriate person, advisor, and senior manager or director if you don't know. The relationship of financial institution and its clients must neither be taken lightly nor treated carelessly, particularly in a legal and global environment that has become increasingly litigious, and where the demands and dictates of pertinent laws, regulations, and international and local best practices require nothing less than professional responsibility, integrity, transparency, and accountability. And now you see why it is so important for the financial institution, when he's deciding to exercise his power of scale, that he has done proper accounting. Now, I don't think nothing is more embarrassing than when the court has to ask a financial institution to go back and submit a proper accounting of a client's mortgage. What image do you think that is giving of that institution? Even though the judge is not involved in what happens in the day-to-day world, but he only deals with the matters that come before him. What happens if he sees that every time there is a matter related to a particular bank, that they have the issue in order that the bank go back and do an accounting? What is that telling the legal, the judiciary?
They're not being responsible in doing their duties.
Exactly. And it shows that there are some gaps in their procedures. And you've seen that in some of the cases that we read. Because you can't go to court and tell the court, oh, we had system A, now we have system B. That's why we have a difference. If you're taking a matter to court, then you need to sit down and run that account from the very beginning to the very end and make sure that the numbers are correct. Because always remember, when you're dealing with anything to do with banking law, everything comes down to that contractual relationship. And that contractual relationship speaks to the banker and its client, its duties and obligations. That's the overarching framework for that relationship, that contractual arrangement between the banker and its client. So even though there are legal defenses and there are remedies in that banker-customer relationship, everything depends upon the action of the parties and who is complying with the mandate. That means who is complying with the duties and the obligations as set out in that banker-customer relationship. When you onboard a client, or let's take, for example, some of the other cases that we read. You have a client come in, they sit down, they say they want a mortgage to finance whatever building, boat, vehicle, but in a space of 1 to 2 years, they're in default. The question is whether or not the organization paid any attention to the risk. In granting that facility. Because you have to be able to mitigate against the risk and any other defense that may come up by the client. You got to think about the cost of the action. How much is it going to cost you? The time it's going to take to adjudicate. The publicity, because as you can see, the cases are online for anyone to read. Whether it's convenience or inconvenient, because sometimes the person who might have been responsible for the account is no longer there. Someone else has to do it. And of course, the need for a ruling, because you can see in some instances, these matters go on for years. So that's why you'll see, remember when we did remedies, what was the first remedy? That was one of your multiple choice questions. What's the first remedy when there is a default?
I can't remember the name, but it's that, what do you call
A.
it? A, which was a demand letter, but you have another name,
Action for debt.
action for debt.
Yes. So that's always the first step you take. And when you do an action for debt, what does that involve? It involves you putting all your facts together, investigating everything, reviewing it, analyzing it. And you look at what are the strengths and what are your weaknesses if you were to take this matter to court. And at the same time, you have to look to see whether or not the financial institution has complied with its contractual duties. So whenever we're talking about mortgages, or we're talking about car loans, so we're talking about anything to do with credit. Credit risk, as you know, is one of the, I guess, main areas that the regulator focuses on. Because that risk, as the assets deteriorate, affects capital. So credit risk is defined by the OECD, is the risk that one party to a financial contract will fail to discharge an obligation and cause the other party to incur financial loss. And that's what happens when there is a default in a mortgage. The central bank says credit risk is the risk of financial loss, despite realization of collateral security or property, resulting from the failure of a debtor to honor its obligations to the licensee. When I drive around, I see a lot of houses abandoned, and they're actually decaying. So my question is, whenever they do get a sale, if they get a sale, those persons who borrowed those money have a huge debt to pay. So I wonder how the credit bureau will work. So exposure to credit risk has been one of the leading causes of the myriad of problems that many banks face in recent times due to lax credit standards for borrowers and their counterparties, poor portfolio risk management, weak systems and controls for credit risk identification, assessment, mitigation, and management. The principles of effective credit risk management are as follows: establishing an effective credit risk environment, operating a sound credit granting process, maintaining an appropriate credit administration measurement and monitoring process. Credit management, risk management is one of the primary functions that relate to mortgage lending and the performance of banking services in relation to profitability and increased shareholder value within financial institutions. So for those of you who actually sit in the front as a loan officer, you have to focus more on that banker-customer relationship and being professional and the fiduciary duty. Those who work in the background in credit administration, they're looking at the risk, identifying the risk, the risk in each client who applies, saying that they can assess that risk, that they have the policies in place to mitigate against that risk, and that they can manage it over the duration of the mortgage. So look again at some of those cases we did. A lot of those persons who applied for those loans were not able to keep up with the payments. And in some of those, I know when you read some of those, you realize that some of those loans should not have been granted. So do you think now that with the implementation of the credit bureau, it would make the risk less than it was before because you won't be guessing? That you will have a
No.
better
I
risk
think it will help.
management? Go ahead.
Yes, it might help, but they would still try to see how best that they can lend. So they may overlook some of the regulations in order to try to assist the customers to get that business.
But be mindful of what the Prime Minister just said today. What did he say? Yesterday.
Sorry, I didn't hear.
Oh my Lord.
I don't listen, sorry.
What did he say, Miss Archer? I know he,
We're supposed to watch our spending more or less because we're
Yes.
gonna have a rough road coming.
He said that the group of governors in the world had a meeting and they said that the recession is here and that we're roughly at 2%. We're looking at 7%. And he said to tighten your purse. It's going to get worse before it gets better. So to me, when a statement like that is made, and I'm sure you will see it when the governor writes his next monthly report, you have to look at your portfolio. If a recession comes, and we've had many recessions before, so you should have someone in your organization, if you're a local bank, someone in there who is responsible for looking at economic forecasts. If you're an international bank, that information, along with what's happening in your head office, should be coming together to look at the portfolio. Because now you have to reassess your risk. which clients are the ones who are going to be in default first? What plan do we have in place to assist those persons? How are we going to mitigate against this? Because they're going to have to project what's the fall off going to be. Because things are going to get tough.
Yeah, they get it.
So your dollar is worth how much now? How much is your $1 worth? Because they can't buy a chocolate bar no more. And all chocolate bars over $1.
Yeah, it's just about.
That's about. Okay, so how much is your $1 worth?
50 cents.
I'm gonna say 75, but okay.
I'd say 75.
75? And that's at a
About
2%.
50 cents.
So that's at a 2% inflation. So imagine 7%.
At least the dollar could still buy the newspaper.
But you all don't buy the newspaper.
No.
Yeah, I spy. Well, I spied on Thursday. I gotta make sure I ain't in there.
Oh, God. It could be a mistake. It could be. But these are the things you seriously have to look at when you're lending. So you have to look at people in certain industries to see how the recession will impact them. Look at the number of children. You have to think about food. Because everything is going to cost a lot. So before you would have taken a gallon of water or a gallon of juice and drank it in 2 days, you now have to stretch it to 4 days.
But Ms.
Maybe-
Ask- Sorry,
Go ahead.
sorry. When it comes to the recession, right, and businesses like banking, you're telling officers they're gonna have to tighten up and so forth. But company-wise, the company may not be saying tightening up to some degree because remember now, some officers, they have quotas. So because there's a recession, you don't think the company will be trying to get what they can and officers trying to meet these quotas? I think that's part of the problem too.
Yeah, because now what you gotta look at is, it's like you're fishing. Your net can't be as wide. You understand what I mean?
More quantity than quality.
Throw your net out.
Quality,
Yeah.
more over quantity.
So
Okay.
the persons that you would not have targeted, you now have to target. One, to meet your quota, and two, to get the quality you're looking for. Because what's going to happen is that you're going to be having a lot of actions for debt. Because don't forget now, it's like we said at the beginning, everybody is happy when they get a mortgage. They skiddly doing running out of the bank. And then when they get in tough times, what happens? Oh, you didn't tell me that I was going to lose my house. Oh, I thought I could have just paid something on it. Remember the case with the husband and wife? Where the husband wasn't paying, but the wife funds were still coming out of her salary. And they thought that they were okay. It doesn't work that way. So all these things you have to think about. And so higher up, if you look at your risk department, they're looking at not just credit risk, but they're looking at financial risk, liquidity risk, legal risk, liability risk. And of course, if you don't manage that risk properly, then of course you're gonna have regulatory risk. And then if restrictions is put on the bank, you're gonna have some compliance risk. And if you have a lot of lawsuits, you're gonna have reputational risk. But it's just some food for thought. When I heard him speak, the little clip they put on, I said, you know, you as bankers, you have to be mindful and listen to these things. You should read the monthly economic report so you know where the country is headed. So you know which market or which group of persons to target for loans. And then, of course, you have credit policies, and you have to make sure that those policies are able to mitigate against things that are expected. So it isn't just about booking the loan, but it's also looking at the risk. Any comments? No, yes?
No, it's just an eye opener. For real. That really sad.
I just want you to be mindful. Because even though, like, if you're in the front, any of you in the back doing the risk part of it itself, doing the credit administration from a policy perspective, because that's an interesting arm of credit. Looking at policies and procedures and looking at assessment of risk. Reviewing the portfolio, looking to see if the security is adequate.
No, ma'am.
No? Oh, that's an exciting job.
We have a whole department for that, with the securities clerk and legal department, so.
But you don't have like a back office credit administration.
Yes, in every branch, you would have a securities clerk that would go over every file, for credit,
Mm-hmm.
and, you would liaison with compliance and the legal department.
Okay, okay. But there isn't one that looks at the overall policy, your credit policy.
Yes, that would be
Oh,
at the head office level,
Oh, you don't have anyone locally that does it?
not
Like-
in each branch, no. We
No,
would have one
okay.
at head office, and then there'd be a securities clerk at each branch
Right,
to
okay,
assist.
yeah, I got you. Yeah, so I think that's it for tonight. We have one more class. And I have to let you all know what areas are going to be on the exam. I'll have to see. I mean, I already have putting some ideas in my head already, so I will let you know on Saturday, and I'll give you the cases too.
Okay,
Okay?
okay.
Don't
Okay.
worry. Have a great evening.
You too. Miss
You too.
Archer, sorry, how much
Yeah.
class, how much, cases you had me down for?
What is this, Cleopatra?
No, that's Dora.
Oh, that's Dora. Hold on. Dora, I have 3.
I think I did 4.
You could be, that's what I'm saying, because I know there's one I sent an email.
Yeah, I think I did 4, Miss Archer.
Not a problem. I'm not gonna kill you.
No, I just thinking out loud. I think it was 4.
Okay. So you want me to go over the numbers again, everybody, or we good? I think we good.
Yeah, good.
Yeah, okay, all right. All right, so Saturday morning is our last class,
Okay,
and after that, after the end of class, and I'll tell you what's the areas for the exam. Okay,
okay.
Okay.
all right. So have a good
Good night.
evening,
Good night.
Evening.
Good night.
Evening.
everybody. Good night.